What's going on, guys? It is the Wolf. This is the last 25 or 6 pages of the Right to Travel legal guide. I appreciate each and every one of you guys. It is late night here. It's my last recording before I go to sleep because I'm tired. It's been all day of recording and whatnot. But I do this for you guys. I do it because I appreciate you. I love it myself. As always, hit that bell, like, subscribe. Just know that you know, working together, differences aside, for the common good is why we do all this. For future generations, every inch we take back of this mountain that they put in front of us and on us is a victory. So let's get it. As always, you guys can check out all my good works, files, support, donate, resources on blacksite32.com. It's also jamesclovett.com and Badwolf Unincorporated.com. All right, guys, with that being said, let's get ready to talk about the anatomy of a traffic infraction. All right. So with that being said, let's make sure everything is set up. Boom, boom, boom. Sharon, all right. Let's go.
Anatomy of a traffic infraction. One might be wondering, where is the written authority for the police power to be executed against a personal private traveler? Nowhere. The threshold of the police power, at least as far as statute traffic regulations are concerned, is the public enterprising businesses. Initially, in this section, remember that possession of a driver license and a vehicle registered to the state is a public benefit of business grant from the state. What is the point of challenging a traffic infraction? Perhaps even to challenge personam jurisdiction or subject matter jurisdiction. What of an effort to challenge the facts that gave rise to the infraction? Perhaps a challenge that the infraction failed to give notice. A citation by definition is a command, by way of writ, from an agency head or a policy dictate, sometimes issued by a court, to compel an officer of the court to do a thing. An arrest warrant is a per se citation. The traffic infraction issued by a policeman is a violation of the separation of powers doctrine. A court is only supposed to resolve disputes and settle claims between litigants, based on the facts brought by either party.
Okay, so hold on, guys. This is the gem drop right here. Gem drops. You guys reading this? Hold on. Let me see if I can make the picture bigger here too. There we go. A citation by definition is a command. You are not their property. But see, the problem is they get over on you because you got that driver's license. And then you registered your vehicle. You double downed. So by way of writ from an agency head or a policy dictate, the court didn't issue it. The court is only there to see it. They're sneaking around the back door giving you that old hey, how you doing? To compel an officer, you're not an officer of the court, to do a thing, which is what the president, Biden at the time, gave a mandate. It's the same thing. These aren't for us. An arrest warrant is a per se citation. It's not, once again, they're not for us. They're not an Article 3 judge court warrant. They're bench warrants. They're not real actual federal ones. The traffic infraction issued by a policeman or woman or person is a violation of the separation of powers doctrine. This is huge because they're acting as judge, jury, and executioner. You cannot be the executive, the legislative, and the judicial. Can't be all of them. That's what they're doing. A court is only supposed to resolve disputes and settle claims between litigants based on facts brought by either party. You're not they're not you're not this is not a litigation. It's more or less a tribunal and they're gang stalked you, trapped you, brought you into something you're not even supposed to be a part of in the first place. But let's keep going.
As it pertains to a traffic infraction, the judiciary has stepped across boundaries and issued a citation commanding the executive branch to use the court's format for an infraction notice, whereby providing to the executive branch a pleading document intended to perfect judicial appellate jurisdiction. The executive branch citation, aka traffic infraction, is an executive branch citation, which, on the reverse, gives the option to appeal the infraction to a lower court. The appeal to a lower court is descendant of an executive administrative action. As citations go, look to Infraction Rules for Courts of Limited Jurisdiction 2.1a, IRLJ 2.1a, which reads as follows. Infraction form prescribed or approved by the Administrative Office of the Courts. Infraction cases shall be filed on a form entitled Notice of Infraction, prescribed by the Administrative Office of the Courts. Notice of infraction forms prescribed or approved by the Administrative Office of the Courts are presumed valid and shall not be deemed insufficient by reason of defects or imperfections which do not prejudice substantial rights of the defendant. The preceding citation is found at the bottom of a traffic infraction. Notice at the bottom of the infraction claim form the words Washington Uniform Court Docket. This form of infraction, or writ, is a command by the judiciary to the Executive Department of Government, the police, to provide the judiciary with all of the jurisdictional information they need to perfect the state's claim. Everything that happens in a courtroom happens at the discretion of the judge. However, be equally assured that the judge will use that discretion to the best benefit of the state, because as the rule above indicates, an infraction is valid so long as it does not prejudice substantial rights of the defendant. And a driver's substantive rights will not have been violated, because the driver is presumed to have knowledge of the constructive contract. See definitions. Because several statutory alternatives for meeting that element were based on conduct alone, the statutory scheme created a strict liability crime, requiring no proof of the defendant's intent. State of Washington v. Stephen Mertens. Mertens. 2003. The policy enforcement employee is only enforcing a contract that was made to operate a business, and the judge is fully cognizant of that contract. Race Y, the infraction contains a certification by the police employee that everything is as true. The undersigned certifies and says that in the state of Washington, your legal person information here did operate the following vehicle/motor vehicle on a public highway and your business information here did and then there commit each of the following offenses, statute violations here. I certify under penalty of perjury. /s/. On the infraction, there are 3 jurisdictional balloons. The first balloon contains a person's employee driver license number which certifies the person to be a driver. It also contains all identifying information about T legal person. It also contains a block for the identity of the employer of the driver. It also contains several blocks which indicate that the statute violation occurred within the venue jurisdiction of the state of Washington and/or the local jurisdiction. The first balloon gives the court indisputable personam jurisdiction. The second balloon contains all of the business identifiers, as far as the DOL, DMV, and DOT are concerned, saving taxing regulations, necessary to convince a judge that in fact, there exists a business for the proprietary jurisdiction of the police and the latent jurisdiction of the court. It contains the business name and address as well as the business vehicle identifiers, primarily the license plate number. The license plate number itself is tantamount to a master business license, and as such, is a physical address, as it were, of the business vehicle, much like a street address if the business were located on real property. Occasionally a policeman will write "same as above" in the owner box. This is because the owner/operator of the business occasionally is driving his own business. The second balloon gives the court the first element of subject matter jurisdiction, being that the business is conducted within the state of Washington. This third balloon gives the court the second half of subject matter jurisdiction. This balloon calls for the specific statute code section purportedly violated. The box labeled DV is an acronym for domestic violence. As for wanting to argue facts, when a person checks the box to request a mitigation, appeal, hearing, he is not only acquiescing that he committed the violation, and subsequently wants to negotiate the damages he caused the state, asking for equitable review, he also, in end of his heuristic delusion, has voluntarily given the last element of subject matter jurisdiction, which are now the facts in evidence. All totaled, the court has complete and inescapable jurisdiction to uphold the executive decision. Damages? Yes, damages. When a traffic violation is alleged, it is a suspect determination that a driver has disrupted the flow of traffic or caused there to be a potential public risk circumspectly harmful to some other fellow traveler or commercial enterprise. So, in the estimation of the state's regulatory police power, it is deemed suitable to issue a warning, as it were, that the conduct is suspect, and that the driver surrender some consideration of penalty, money, intended to be a form of behavioral modification. Tort liability. The journal discussion below, not intending polemic discourse from the significance of the article, has been taken excerpt and edited for content. The journal article is a discussion of the differences between those who are specifically invited, impliedly invited, and those who trespass for want of permission to enter a premises. The article also discusses the liability of tort, or percent thereof, for injury while on those premises, with respect to the type of permission granted, implied or expressed. The article lays out differences between property owners versus lessors of property and their relation to the permission given. As a matter of course, of and for expurgatory value, there also is intold of a right of passage on property. It is the last which the discussion here exemplifies. As we move through the actual article excerpt, be mindful of the following terms. There is significance in these terms as we substitute them later. Owner, occupier, licensee, defendant, invitee. Bear licensee. Visitor. Premises. Property. Dangerous. Condition. 63 Yale Law Journal 605. Rule: even where the occupier knows of a danger, he owes the licensee no duty of precaution if the danger is perfectly obvious. This rule has sometimes been put as a duty to warn the licensee of a known trap, and some of the older cases considered a condition a trap, if it was dangerous and very much concealed. The licensee must show defendant's knowledge of the dangerous pitfall, whether it be natural condition or arrangement of premises, or that he made an inspection which would have been likely to disclose the dangerous condition to him. If he shows that defendant created the dangerous condition, which will suffice. While plaintiff must show defendant's actual knowledge of the condition, defendant will be held to appreciate its danger if a reasonable man would do so. An interesting question is posed if defendant created a condition which was not dangerous at the time but which would foreseeably become dangerous. There are a good many dicta, mostly in older cases, and some holdings to the effect that the occupier of land owes the bare licensee no greater duty than to refrain from intentional, or willful or wanton, misconduct towards him. Once a person's presence becomes known, the significance of the classifications largely disappears, and he is owed the duty of reasonable care as to activities, whatever his status on the land. This does not mean, however, that the plaintiff's status may have no bearing on what conduct defendant may reasonably expect of him. Cites omitted. The occupier is commonly said to owe greater duties to his invitees than to licensees, notably with respect to inspection and discovery of latent dangers on his land. The economic benefit theory proceeds on the assumption that affirmative obligations are imposed on people only in return for some consideration or benefit. Any obligation to discover latent dangerous conditions of the premises is regarded as an affirmative one, and the consideration for imposing it is sought in the economic advantage, actual or potential, of the plaintiff's visit to the occupier's own interest. It is not the fact of invitation, nor of the knowledge of the probability of the customer's presence which this implies which raises the duty, but the purpose of the visit and the occupier's interest therein. Cites omitted. The invitation test does not deny that invitation may be based on economic benefit, but it does not regard that as essential. Rather, it bases invitation on the fact that the occupier by his arrangement of the premises or other conduct has led the entrant to believe that the premises were intended to be used by visitors for the purpose which the entrant was pursuing, and that such use was not only acquiesced in by the owner or possessor, but that it was in accordance with the intention and design with which the way or place was adapted and prepared. Even an express invitation might not raise such expectations, however. It has been applied particularly when premises were prepared for the public or a segment of it. A business visitor is a person who is invited or permitted to enter or remain on land in the possession of another for a purpose directly or indirectly connected with business dealings between them. Cites omitted. W. Hen one expressly or by implication invites others to come upon his premises. Reasonably sure. Exercise ordinary. Whether for business or for any other purpose, it is his duty to be. That he is not inviting them into danger, and to that end he must care and prudence to render the premises reasonably safe for the visit. Commercial business is moved by a lawful invitation. The enterprise interested therein, or that. Cites omitted. Mutuality of interest does not mean that there must be a transaction between the parties, but merely that each party purpose or interest in the object and subject matter of the must be mutual to the extent that each party is lawfully. There is a common interest or mutual advantage involved. In other cases, there has been no arrangement of the premises so as to induce entry, and the significant factor is the economic benefit conferred on the occupier by the visit. This is true of the person summoned to transact business with the occupier, whether the premises be arranged for business. Viewed as indirectly incidental to an economic benefit, it seems much more to the point that such people know that the occupier is required by law to receive them, and so have reason to believe that their coming is anticipated, and that the premises are ready for their reception. There is no reasonable distinction between the rights of a person visiting the premises for the purpose of escorting another to a departing train, and the rights of one who goes there for the purpose of talking with a departing person on a business matter. There is a wide difference between the use of the premises with such motives, the latter, and those of idle curiosity and merely to kill time. The former. Cites omitted. These cases can be reasonably explained only by the invitation theory, as can the cases involving an apparent extension of the highway. If a man arranges part of his land so that it looks like an extension of the public sidewalk or roadway, a traveler who takes it for such as an invitee, though his entry onto the private land confers no benefit whatever on its possessor. It makes no difference that no pecuniary profit or other benefit was received or expected by the society. The fact that the plaintiff comes by invitation is enough. Cites omitted. If, on the other hand, defendant arranges part of his premises, leading a visitor reasonably to think they are included in the area of invitation, he will be held as an inviter as to that part even though he did not mean to invite the plaintiff to it. The occupier's duty to the invitee is one of due care under all circumstances. If plaintiff is an invitee at the time and place of his injury, the occupier, of course, owes him all the duties he owes to trespassers and licensees. Thus the occupier must use care not to injure plaintiff by negligent activity. In addition, the occupier owes the duty of care to inspect his premises and to discover dangerous conditions. This is the most prominent difference between the rights of invitees and those of licensees. The occupier need not invite visitors, and if he does, he may condition the invitation on any terms he chooses, so long as there is full disclosure of them. If the invitee wishes to come on those terms, he assumes the risk. But here again, the basis of defendant's truncated duty is not his superior knowledge, but his ownership and control of the unreasonably dangerous condition. Under this rule, the occupier's superior knowledge might properly be called a condition of liability, but it is not a reason or justification either for the occupier's duty or for the limitation put upon it. Defendant claimed that its only duty was to warn, but the court answered that it did not recognize it to be a universal rule that an owner who invites the public upon his premises for business or pleasure may, in the absence of reasonable necessity, maintain thereon dangerous agencies, as wires charged with deadly currents of electricity, in such places as to endanger life and limb, and escape liability by maintaining danger signals or otherwise advising the public. Cites omitted. In cases where the invitee's recovery has been denied, contributory negligence has often played an important role, and is sometimes hopelessly confused with the duty issue. If contributory negligence would always bar an invitee who was injured by a condition of the premises which he knew and appreciated, the confusion would do little practical harm. Most of the decisions denying liability are rested equally on the ground of contributory negligence. Curtis v. Traders Nat Bank, 314 Kentucky 765, 237 S.W.2D76. These situations show that the invitee will not always be barred by his self-exposure to known dangers on the premises. This means that the restatement rule will sometimes bar a plaintiff, who has not been negligent, from recovery against a defendant who has acquainted the plaintiff with the condition which would be negligent towards him if a full duty of care were owed. A right to enter also stands on a footing different from the privilege which the occupier is free to withhold or to give by invitation or permission. This does not mean that visitors in their own right should all be accorded the same treatment. They are not, and probably should not be. Rather, it casts further doubt on the utility of the present system of fairly rigid classifications. End underscore 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 underscore.
All right. So the last little bit here, some tidy up pieces. So let's finish up with this last little bit here.
What does all this mean? It means that the state should take caution to warn travelers that an application for a driver license or an operator's license moves the traveler from a free use category to a full-time regulated business category. Conversely, a traveler has an obligation to make his non-business presence known to the state. The state owes a duty of full disclosure as to the distinction, purpose of, and use for, the application for driver/operator license. When that free-use traveler distinction is made, the several classifications of vehicles and motor vehicles become irrelevant. The state's regulatory authority stops predominantly, not entirely, at the regulation of businesses. The state has a duty to protect all travelers as members of the general public, all the while it is surveying the roadways affecting its business regulatory police power. The state cannot force an individual into a business license of any kind and must accept the private traveler on the common highway.
There it is.
Licenses are for the conduct of businesses in commerce, and the private traveler cannot be forced by attrition to relinquish or surrender his common law access to the highways for some license to engage in a business pursuit. The state has an obligation to allow private use of the highways. When a policeman stops a traveler, he is trespassing, creating a private nuisance. If the policeman issues a traffic infraction, he creates an aggravation of circumstance. Although the infraction is tantamount to a solicitation, and thusly, an invitation to engage in a secured transaction, saving elaboration, CUCC 1 etc., offering an opportunity to the traveler to submit to state jurisdiction and or admit that someone was actually driving a business. The nuisance theory is reciprocal. It is this nuisance, post-trespass, which creates the tort liability of John Doe policeman. The fact that John Doe policeman has impeded the ability to travel, he is the very epitome of an obstruction. Black's Law Dictionary defines nuisance as nuisance. 1. A condition or situation that interferes with the use or enjoyment of property. A nuisance is a state of affairs. To conduct a nuisance is a tort. The right of the public in a common highway is paramount and controlling. This right extends to the entire territory within its limits, and an obstruction placed upon any part of it constitutes a public nuisance. Commonwealth v. King, 13 Met. 115. The law applied to motor vehicles, Babbitt C. 1911, citing Morton v. Moore, 81 Massachusetts 573. To further define nuisance, we'll look to Washington statutes to discern between a public and a private nuisance. First, we find a poignant statement of nuisance affecting state actors at RCW 7.48.120, which reads as follows. Nuisance defined. Nuisance consists in unlawfully doing an act, or omitting to perform a duty, which act or omission either annoys, injures or endangers the comfort, repose, health or safety of others, offends decency, or unlawfully interferes with, obstructs or tends to obstruct, or render dangerous for passage, any lake or navigable river, bay, stream, canal or basin, or any public park, square, street or highway, or in any way renders other persons insecure in life, or in the use of property. Emphasis mine. Below is the distinction of public versus private. Carefully noting, though, that a public nuisance is when an obstruction affects the whole of the public, as likened to a roadblock or fallen tree, which prevents passage to all people. RCW 7.48.130 reads as follows. Public nuisance defined. A public nuisance is one which affects equally the rights of an entire community or neighborhood, although the extent of the damage may be unequal. Italic mine. Traveling privately is not unlawful. Conversely, police license regulation directed to private travel is not lawful. What concerns the personal private traveler is the following statute. The private nuisance is one that affects an individual interest, and not the whole of the public. RCW 7.48.150 reads as follows. Private nuisance defined. Federal Administrative Procedure Sourcebook, 4th ed., 2008. That the streets of the city are highways of the state, and therefore public roads which every citizen has a right to use, is a valid argument against stopping or unreasonably hindering travel over the streets, but it is no argument at all against subjecting travel over those streets to rules and regulations. Emphasis mine. The law applied to motor vehicles. Babbitt Section 43, at 112 citing, City of St. Louis v. Green, 7 MO App. 468. However, should a person actually possess a driver or operator license, admittedly suffers the contributory negligence learning curve. Notwithstanding that, an individual can use a company vehicle without a driver license, according to the Scheffel Court, State v. Scheffel 82 WN2 D872, the fact that a business license is in effect on the vehicle pugnaciously mandates that a person take up the traffic infraction solicitation and go to court and mitigate the damages, because the alleged driver presumptively falls under the prescript of the statute regulation.
Did you hear that? It says an individual can use a company vehicle without a driver's license. That is something I did not know. Because the business has the license. The business is the legal person that has the license. You don't need one when it has one. Interesting.
Regulation. People have a right to the use of the common highways, but equally have an obligation to notice the state of that intended use, for the simple reasons that one is simply exercising the existential right to free use of the highways and is not an enemy combatant. Once notice is given the state, by any one.
When have I told you guys about being an enemy, a combatant, non-belligerent, non-combatant? Because in their tribunal maritime water jurisdiction, they think that you are anybody not with them is a combatant or an enemy. And it's a war. They're warring on the American people.
One or more agencies, of the status as private traveler, the full weight of tort liability falls on the policeman who actually engages and detains the personal private traveler. If the police are going to enforce the law, they should know the law, the effect for and the effect of said law. Is the vehicle license plate number **** a business license? Is the license plate number **** a vehicle business license? If **** is not the business license number for the vehicle, please provide the business license number for said vehicle. At the time of, and upon, the application, in ****, for a vehicle license, what was the name of the business printed on the application for license? At the time of, and upon, the application, in ****, for a vehicle license, what was the type of business the vehicle was registered under? Please provide a copy of the application for vehicle license, congruent with the vehicle license stated above. Please provide to me a copy of the original application for vehicle license on a specific vehicle. Please also provide a copy of the original application for driver license for a particular person. Please also provide a copy of the original application for an operator's license for a specified person with a known, specified, license number. Attached as a separate PD was a question as to the DOL's use of the term personal driver license, which is the term the DOL uses on their disclosure form in response to a state request for a driver abstract, when they suspend the driver license of a driver. Included in this query was the use of the term private driver license. The DOL does not know what a private driver license is, no responsive record found. See responsive items 11 to 12 below. In response to the question of a personal driver license, the DOL stated it thus. Finally, in response to your question, is there a specific statute that uses the language personal driver license? I can only reassert that the statute I provided, RCW 46.20.001 provides the authority for driver licensing. No person may drive a motor vehicle upon a highway in this state without first obtaining a valid driver's license. Emphasis added. As to the question for a copy of the driver license application, a notarized form swearing that the information would not be disseminated was sent, intended, as requested, to protect personal information. A response came back telling me that the information would not be released because it contained personal information and also that the record of question was aged and unavailable. The DOL was asked to provide a copy of a blank form application for vehicle license and a blank form application for driver license. While waiting for a response to the vehicle licensing questions, a PD was sent asking if the DOL has a form similar to the U.S. FMCSA, Federal Motor Carrier Safety Act, DOT 150. The DOL response is that the state does not have a form similar to the DOT 150. In response to the question of application for vehicle license, the response came back with a blank specimen vehicle certificate of ownership, title, application. Along with that was a computer-generated application for driver license. No hard copy form exists for inspection prior to application, as noted in Item 6, response below. 5. A blank copy of application for vehicle registration. Requested by email of Sunday, October 11, 2009. A copy of the vehicle certificate of ownership, title, application form is enclosed with the posted copy of this letter, and under the file name VE Reg application PDF accompanies the email carrying the electronic version of this letter. 6. A blank application for a driver license. Requested by email of Sunday, October 11, 2009. Interestingly, this form does not exist as a paper form, nor can it be printed as a blank form. The application for a driver's license is completed by the licensing services representative questioning the applicant. Only then is it printed, after which it is signed by the applicant. An example of both the record of application and application for commercial driver's license from a record creating for system testing is enclosed with the posted copy of this letter, and under the file name dlapplication.pdf accompanies the email carrying the electronic version of this letter.
So in general, what they're saying here is all the proof that you're operating privately can be sent in and used for your defense. So here they're talking about even in the license plate is a difference between a passenger carrier and a common carrier. If this is true, then from what I understand, the common carrier is exempt, whereas a passenger carrier, which might be in, I don't know, I haven't had a driver's license in years, so I couldn't tell you, but I think most of them are in this format, which means when we're doing this, we're applying for a passenger carrier and not a common carrier. But this also may be in your particular state. So let's see, three sponsors stating that our plates are passengers and the plates are for trucks. Okay, so let's tidy up. Let's go for the query. And then
SES were resay.
Looks like she's getting tired for the day. Let's see. Try one more time.
To galvanize the certainty in this writing that license plates are business-related, these questions were asked of the DOL, but notice below that the DOL has declared the license plates to be an unidentifiable record, and further, will not definitively say yes they are business license plates, either will they say definitively no they are not business license plates. Query.
So that in itself tells you that they're hiding it. That tells you that that is quasi. Which means it cannot have standing. You can challenge that because in this particular case, because they're not clear on it. If they're not clear, it's not the law, even amongst
1.
their
As
own.
it pertains to the license plate configuration and the relation to the attached disclosure request, could you please state with clarity whether these are in fact license plates issued to carrier businesses, and in so stating? 2. I would ask that you answer the disclosure request and state with clarity if an application for vehicle title and an application to register a vehicle is in fact registering a business. 3. I am still not clear on the term personal driver license. Ben attempted to locate the term personal in statute but could not. I ask again, could you please tell me what statute I can find the term personal as it exists on the attached DOL research document? 4. If the term personal does not exist in statute authority, could you identify the term as a misnomer or provide statutory authority to issue personal driver license?
The fact that they won't address personal driver's license because that mixes it up. Once again, they own the word drive, but if you have the word personal, that means it's not business. But because they won't define this, you can use that against them that one, they don't offer it, and two, that a driver's license must then be business if it's not declared to be personal. You can use these things in reverse on them.
License. Response. We have provided all the public records you requested. Your remaining questions below are not requests for identifiable public records. Since I am with the Public Disclosure Office, I can't effectively respond to them with the exception of Item 2. The titling and registration of a vehicle is not the same as obtaining a Washington state business license. Our website gives a very nice guide to business licensing at website omitted. Some business own vehicles and register the vehicles under the business name. Of course, you know from prior communications that state agency staff cannot give legal advice and will not indulge in speculative interpretations of the law. As seen from the above PD response, received from the single, sole, and only agency responsible for issuing license plates in the state of Washington, when asked if the license plates issued are for carrier businesses, and in so doing, if applying for title to register a vehicle is in fact registering a business, the DOL's response is that they are not requests for identifiable public records, and that the DOL can't effectively respond to them because to do so would be to engage in speculative interpretations of the law. When we resort to the maxim of law, being the expression of one thing is the exclusion of the other, and then look around on the highways, what is found is that 2-door and 4-door sedans, station wagons, and smaller sport utility vehicles all adorn the 000 AAA license plate. Now if a taxi cab business has this license plate, what does that make the rest of the vehicles? If the answer is passenger carrier business, that's correct. Were the quarterly business taxes paid to the Department of Revenue? On the other hand though, notice that the larger sport utility vehicles and pickup trucks and vans all have the same A00000 a license plate that is found on the semi-tractor trailer big rigs and community transit buses. If it is the expression of one thing, that the license plate nomenclature as 00000A is a common carrier, Does that make John Doe's pickup truck a common carrier? Absolutely it does. So, to be the exclusion of the other, or common traveler, no registration, title, or license as a business is required. On the computer-generated driver license application form that was received from the DOL, after a few requisite questions, mostly questions establishing a legal person and its residence, there is a signature line certification. First, it must be sworn that the person applying for the license is the person signing. The second half of that certification reads thus: I grant the Department of Licensing permission to consider this application with the understanding this permission cannot be withdrawn. Addressing the above certification, notice the terms grant, permission, and consider. First, the signer makes a grant to the state, which is in retrospect, the exact consent which is required, according to the State of Washington Constitution at Art. 1 Section 1, by the consent of the governed, as seen by reference to the definitions below. Webster's Ninth Collegiate defines grant as 1. VEA, to consent to carry out for a person. B. To permit as a right, privilege or favor. N3. A transfer of property by deed or writing. Webster's Ninth Collegiate defines convey as 2. C. Steal, to carry away secretly. D. To transfer or deliver to another, specif, to transfer by a sealed writing. Webster's Ninth Collegiate defines permission as 2. N. B. Formal consent, authorization. Webster's Ninth Collegiate defines deed as 4. En. A signed and usually sealed instrument containing some legal transfer, bargain, or contract. Black's Law Dictionary defines grant as 1. N. An agreement that creates a right of any description, other than the one held by the grantor. Examples include licenses. 2. VB. To formally transfer **** by deed or other writing. Black's Law Dictionary defines convey as VB. To transfer or deliver **** to another, ESP by deed or writing. Black's Law Dictionary defines permission as 2. A license or liberty to do something, authorization. Black's Law Dictionary defines deed as 3. N. At common law, any written instrument that is signed, sealed, and delivered and that conveys some interest in property. A driver license is not, in and of itself, a per se state business, moreover because the driver license is simply an identification of an employee's particular task. However, the spurious fraudulent act that the state of Washington has committed is to combine, by statute definition and purpose, RCW 46.20.040, the operator's business license with the driver license, whereby the grant to be considered is not simply a request for a driver license but that the state has created an operator paradigm business without noticing the applicant of that action, that act, or deed, is the consideration language of the application, where the right to travel was conveyed and converted to the operation of a business privilege granted by the state. Ipso facto, the driver license is a sole proprietor business. To further invoke the notion of constructive fraud, of special note here is that the application for driver/operator license only contains line space for identification of an individual's name, if it was only the operator, business, license, and not the driver license, that one sought to make application for, there is no separate line space to identify a business proper. Also noteworthy is a reference to the application for title. For succinct purposes here, we only need address 2 lines on the application for title. One is the line space asking for a name and the other asking for an address. The address line reads thus: Washington State Primary Residence Street Address, if an individual, or Washington State Principal Place of Business Street Address, if a business, bold mine. The name line only asks for a name, without distinguishing an individual from a business, while the business can be at either of 2 addresses. Interestingly though, saving discussion on the difference of the state of Washington versus Washington State. What is relevant here is the play on words. For example, primary and principal are each synonyms of the other, and the business is the resident, Latin, meaning identity of a thing. In this case, it is the business. There is no separate line to identify an actual business. This coy illusion is unnecessary because all the DOL needs, by statute authority, is an address for the resident. Each of the two preceding paragraphs should be read consistent with the section on statute history.
Did you hear that? You guys always talk about, why do I say resident? There's another way of looking at it. Res, your identity. To reside and enter, or to res, identity, ident.
Earlier herein. When an individual assumes application for a driver/operator, business, license is mandatory, the applicant then assumes he must register his automobile. An automobile purchased from a private sale comes with a bill of sale. The bill of sale is a deed of right of possession. When the automobile is registered, the DOL asks for the bill of sale. Two things happen. 1. The possessor conveys to the state a partial, priority interest of right of ownership, and 2. Grants to the state a consideration for the business that was created. The bill of sale that was freely given over to the state will never be seen again, because the right of possession has been conveyed, and title was claimed by the state. The applicant has now consented and authorized the state police to stop him for any one or more of the statute violations, enumerated in the miscellaneous motor vehicle codes. Produced also from this research were two applications for a license, more appropriately two parts of one application. The first is a general license, and the second a commercial driver license. The first, general license, simple, application having the above described terms. The second, a commercial application which has the intrinsic information contained in the simple license but also has curious attributes. The commercial application asks 4 qualification questions. 3 are highlighted here. 1. Do you drive a vehicle in interstate commerce? 2. Do you meet all the requirements in the Code of Federal Regulations Part 392.11 and 383.51? 3. Do you have a driver license from more than one state or licensing jurisdiction? According to question number 1, if a person can drive a vehicle in interstate commerce, which is federally regulated, he is automatically under the state's authoritative mandate to possess only one license. If the state only allows one license, and this one is commercial, then by what authority is there issued a non-commercial license? The answer is none. Every license is commercial. The second question is vague. It points to Code of Federal Regulation Part, *****. What title of the Code of Federal Regulation? To be ironically certain, Title 49 Code of Federal Regulation Transportation. The third curious attribute to the commercial application is the class certifications list and the signature certification, which reads in relevant part here. The vehicles I drive are representatives for the class marked above. For purposes of this writing, it is the first class which concerns the bulk of the private vehicles that are licensed. The diagram below is shown as it appears on the license application that was provided. The classes of vehicles and drivers thereof are as follows. Class. Endorsements and / or restriction test needed. Passenger / bus. ___ double / triple trailer. ___ tank vehicle. ___ hazardous materials. ___ school bus. ___ air brakes restriction. Note that a passenger vehicle is first on the list of classes of vehicles and drivers thereof. What is interesting about this is that, A, this class appears on the commercial application, not the general application. B, the passenger classification does not have a demarcation line. C, the applicant swears the vehicle is representative of the class marked above. Of the types of vehicles shown, a passenger vehicle, by statute, RCW 46.25.080, is a Class C commercial vehicle. This means that John DOE has sworn that, for example, a Honda Civic is representative of a Class C vehicle. It is a standing rule of law that silence is acquiescence. The passenger class, being absent the demarcation line, is a technical silence as to the applicable choice. However, this absence does not prevent the DOL from making some type of sign or mark indicating the passenger class, thereby assuming this to be the correct class for the type of vehicle registered. It is, for all intents and purposes, a free-for-all default selection. So, this void is itself representative of an unidentifiable public record which cannot be effectively responded to, as it presumes speculative interpretation of law. Remember, there is only one license authorized by statute, and it is issued by authority of RCW 46.20. The special license at RCW 46.25, called commercial, only authorizes the extension of specific performance or circumstance concerning weights, capacities, and cargoes. And every vehicle bearing license plates is a business, registered to some person.
Well, there it is. There it is. Oh, welcome to Badwolf After Dark. Hold on. Oh, there it is. All right. Told you guys I was working late. So that is the last of the legal guide. That is it. Hopefully you guys learned as much as I have. I thought after reading that and adding my own little pieces, that you guys would find it most entertaining. All right, guys, it's time for me to call it a night. I will have this video, um, I guess link, I don't know, should I have it linked back to the first video or to something new and educational? Hmm. Well, I guess I'll figure it out after it's done editing and converting. So then you guys take care. Um, have a great night. Thanks for watching. I'll talk to you guys later. Don't forget to support any kind of way you guys can. Bell, like, subscribe, and of course, blacksite32.com. I accept donations of all sizes, or at least whatever PayPal and will accept and whatever you guys want to send. Other than that, there are lots of programs and other sponsorships and whatever else on Blacksite 32 that can help you guys in numerous ways. So go check it out. Scramble through, look through. I would be highly surprised if you guys didn't find anything of interest on that site, depending on where you're at in life, including how to get in contact with me if you need a consultation. As always, everything is education and entertainment purpose only. These are only my experiences. Yours may vary. We accept no responsibility for anything you do or that's here. Everything here is just informational. That being said, I appreciate you once again. Take care. Have a great night. Wolf's out.